Hey there, thank you for visiting my YouTube channel today. I'm Alex Hernandez. I am your professor. I'm going to talk to you today about the issue of attorney's fees and when it comes to bankruptcy. Now, when it comes to bankruptcy, the first thing I want you to know is, there's always this issue, how much is this going to cost? The reality is it changes based on all the issues involved, the region, the lawyer's experience, etc. But I want you to know that most lawyers do offer flexible payment plans when it comes to bankruptcy. If your lawyer is not offering a flexible, payment plan and it's more along the lines of I need $2,000 right now, shop around. Okay, because there's plenty of lawyers who'll take it, will accept a far less than that and will accept a payment plan, and at least you can turn in the paperwork, get the ball rolling, and little by little start saving money to pay your lawyer. So we would all love to get $2,000, $3,000 down immediately from one minute to the next on a bankruptcy, but that's not the reality. I don't even think that's fair. I've always offered a payment plan to my clients. Now, clients are always going to ask, how can I pay you? Can I pay you with your credit card? No, not a good idea. First place, let's say I'm charging you, we'll say 2,000. Why charge you two? Why not charge you 4 or 5,000? Why not go all the way up on your available credit? You're not paying for it, right? What does it matter? But the answer is you cannot pay your lawyer with the credit card. You can pay with someone else's credit card. That's between you and that person, but you can't use your credit card. One of the reasons, and trustees do look at credit reports when all the documents are submitted to the trustee, bank statements, tax returns, etc. They're going to see, was there a substantial increase in debt prior to filing for bankruptcy? If you're filing for bankruptcy, you're not supposed to use there's exceptions, and I'll go over that later in another video, but you're not supposed to get into more debt. And obviously paying your lawyer, is that getting into more debt? No. But if you're using your credit card, then it's going to be a problem. So this means, very important here, because I see this all the time. Well, if I'm going to file for bankruptcy, I might as well go take that Caribbean cruise. I haven't been to the Bahamas in a while. Hey, let's go visit Orlando. Let's go visit Mickey Mouse. Same thing. You're not going to be able to file bankruptcy. You're going to have to delay the bankruptcy, and how much it has to get delayed really depends on the facts of the case. That's what you have to tell your lawyer. This is how much was spent. This is when it was done. I've had clients that, and Disney's a perfect example. They lived about an hour or two away, and it seemed like they were going to Disney every single weekend. You got to put the brakes on that bankruptcy case and say, come back, see me later, maybe 6 months to a year. I'll let you know, but you're not filing today based on those expenses where you have used up all your available credit to start traveling. That's a big no no. Now, if that issue presents itself, understand that one of the questions that trustees do ask is, especially I see this a lot. So usually they won't come back to the same lawyer. They'll come, let's say I'm the second lawyer they spoke to. And I say, okay, we're going over all the information. I say, when did you get this car? 6 months ago. Hmm. Did you see another bankruptcy lawyer? Yeah. Okay, it's not going to be a problem for me, because I didn't do anything wrong. But sometimes the lawyers will say, well, you don't qualify for bankruptcy, but the way the means test is designed, this weird mathematical formula, is that secured debt kind of lowers your income is the best way of explaining it. You would actually have to sit there and do the numbers so you get a better understanding of it. But when that happens, all of a sudden you had a car paid off, or you only owed 6, 7 thousand, all of a sudden you owe 20,000, you could magically qualify for the means test. And trustees do ask that. So I've seen trustees say, when did you go meet your lawyer? Oh, 3 months ago. Okay, so when did you buy the car? 6, 7 months ago. Again, I didn't do anything wrong, and if I feel comfortable with it, I'll go forward. But you do see that issue, and if that's something that you did, a lot of times lawyers just do quick consultations. They want you in and out the door. I always suggest go get another lawyer if they're in a rush. They're in a rush to see you when you're ready to hand them money. They're going to be less in a rush to talk to you once they received your money. So keep that in mind, because you want your lawyer to be able to answer your questions, or at least your staff. The lawyer, of course, we're not always available, but at least if someone else could help you. But if you're one of these situations where you did meet with another lawyer, then please be honest with the lawyer you're planning to go with, especially if you bought something recently, a secured asset like a car that kind of help you get over that little bump. because that's something your new lawyer should know, and it could affect the outcome of the case and the steps that they're going to take. All right. So, as always, any questions or comments, feel free to post them in the comment section below. I'll be more than happy to respond. Paralegals that are taking your courses, and you're taking bankruptcy now and you're using my textbook in your courses, by all means, same thing, join us. Ask any questions that you may have. Go ahead and post them in the comment section below. Excuse me. Um, Finally, Bankruptcy.blog. I got plenty of information there posted regarding everything from credit cards and mortgages and car loans. So likewise, come check out the blog. It might be able to help you out. If you have any questions, send me an email and I'll be happy to respond. All right, everyone, take care of yourself, be safe, and tell your lawyer everything.